This is going to be a quick lecture, a shorter one, about Model Rule 1.18, which is about prospective clients who come in for a consultation. I confess there have been semesters when I didn't even cover this rule because it's not heavily tested on the MPRE, but the ABA has put out a kind of a emphatic ethics opinion recently. It could be tested, and it overlaps both with the conflict of interest rules and with the confidentiality rules under 1.6. So my first question I have to decide every semester is whether to devote course time to this, and the second is whether to mention it quickly in connection with the conflicts rules or confidentiality rules. And so we're going to kind of just hit the highlights of this. I think it's a pretty intuitive rule here. So 1.18, duties to prospective clients. A person who consults with a lawyer about the possibility of forming a client-lawyer relationship with respect to a matter is a prospective client. By the way, in recording these lectures, I immediately before this recorded a short lecture about Rule 6.5, which is doing one-time only consultations for people that you are not going to represent. And so it might be helpful to watch this in conjunction with the one with the lecture for 6.5 for a point of comparison and contrast. So this is the normal situation where someone comes into your office for a consultation and you're trying to decide whether to represent them. Whether you represent them or not, we are going to call them a prospective client for purposes of the model rules. B, even when no client-lawyer relationship ensues, a lawyer who has learned information from a prospective client shall not use or reveal that information except as Rule 1.9 would permit with respect to information of a former client. And so part of the way that this overlaps with the conflicts rules obviously is a reference to Rule 1.9, which is for former clients. Your big takeaway from this slide or from the A and B of 1.18 is that even if you decline representation, you do have some duties, primarily a duty to protect the confidentiality of the information to a person, even when you do a consultation. And so make sure that you understand that. That lends itself so easily to kind of a gotcha test question where someone comes in for a consultation, they tell the lawyer their whole story, and then the lawyer says at the end, hey, here's a few possibilities. So the lawyer says, number one, I don't do that kind of law after all, I don't want to take it. Number two, or wow, I love this case, but I have a conflict of interest, it turns out, so I can't represent you. Or three, the lawyer says, great, I charge $200 an hour, and the person says, oh, that's like 10 times, I thought it'd be like $20 an hour, forget it. And you're like, what world are you living in? And so they walk out of your office and you never represent them. Or they come in and they say, I have a big case, and you realize, wow, I'm way too busy to take on something. This is going to be a lot of headaches and a lot of work, and I just don't want to do it. And so you send them away. That's fine, right? You don't have to take every case that comes into your office. And so you send them away, but you don't get to go and blab everything that they told you. They were trusting you when they came in to talk to you. Also, we're not talking about attorney-client privilege in this lecture, but when we get to that, I want you to remember this, that if the person came in for a consultation, if they were asking for legal advice or seeking legal representation, even if you don't agree to represent them, even if they never pay you anything, the conversation will be protected by attorney-client privilege, assuming it was confidential and the other exceptions to privilege don't apply. Okay, C. A lawyer subject to paragraph B shall not represent a client with interests materially adverse to those of a prospective client in the same or substantially related matter if the lawyer received information from the prospective client that could be significantly harmful to the person in that matter, except as provided in paragraph D, which is obviously going to come next. If a lawyer is disqualified from representation under this paragraph, the whole firm is. No lawyer in the firm with which that lawyer is associated may knowingly undertake or continue representation of the matter except as provided in paragraph D, which is next. Paragraph D, 1.18 or 1.18. When the lawyer has received disqualifying information as defined in paragraph C, the representation is permissible if, one, both the affected client and the prospective client have given informed consent confirmed in writing, or two, the lawyer who received the information took reasonable measures to avoid exposure to more disqualifying information than was reasonably necessary to determine whether to represent the prospective client, and then we have a little I and a little 2I, or little 1 and 2. The disqualified lawyer is timely screened from any participation in the matter and is apportioned no part of the fee therefrom, and written notice is promptly given to the prospective client. And so here's an example. I'm going to skip some of the comments. Again, I don't want to invest as much time in this rule as I would some of the other the more heavily tested rules in the course. So here's the example from comment 2. A consultation is likely to have occurred if a lawyer, either in person or through the lawyer's advertising in any medium, specifically requests or invites the submission of information about a potential representation without clear and reasonably understandable warnings and cautionary statements that limit the lawyer's obligations, and a person provides information in response. Now, I want to go back for just a moment and look at the what are we talking about. Let's say someone comes in, a man comes into your office one day for a consultation, says, "I want to divorce my wife, and I'm looking for a good divorce lawyer." And you do divorces, let's say, and marriage dissolutions, and so and then as a man explains it to you, either your fees are completely unacceptable, or um, eh, or you just take a disliking to him, or you guys have a falling out or argument, or he says, "So I want to get $10 million out of this," or something, and it doesn't make any sense at all. And so you decline the representation, or he decides not to hire you. Right? Either one. But in the process, he tells you a whole bunch of garbage about his failed marriage, right? About his sex life and his finances and all sorts of stuff. And so the two of you part ways. You're not going to continue with the representation. 2 days later, his wife comes in for a consultation, and you really hit it off. And can you represent that person? No, because you have all this confidential information. And so even though the husband never became your client, the whole point of 1.18 is, because you did a consultation where you let them tell you a whole bunch of confidential information, you're not allowed to provide representation to someone else, or even to share that information, that confidential information. People have a reason. It's reasonable for people to expect that when they go for a consultation with a lawyer, that the lawyer is not going to say, "Haha, I'm not representing you, and I recorded all of this and I'm giving it to the media," or something like that. That's not fair, right? And so we don't want people to have to worry about that when they're going to a lawyer. Now, let's say the husband comes in, tells you all the dirt on his marriage and his personal life and so forth, and his addictions or whatever, his affairs, whatever it is. And then the wife comes in, says, "I want you to represent me." And you're like, "You know what? I think I will." Well, if the husband's like, "Sure, what do I care? Go ahead and represent, and we'll give informed consent," and she will give informed consent, so each affected client, then this sounds like 1.7, right? Where each affected person, even though the first one wasn't a client, that's why we didn't talk about this under 1.7, but if they will both give consent confirmed in writing, then you can go ahead and represent the second party. Now, this may sound unlikely with the husband-wife divorce scenario, but it's not as unlikely. Let's say if you take outsourced legal work, you do litigation for 3 or 4 different insurance companies, Nationwide and Geico and Progressive, and Travelers or something like that. And so you you represent them, and these corporations may not really care. They may have talked to you about outsourcing something to you, and then you decided not to take the case. And then the other party in the case, their insurer wants you to represent them, and the first insurer may say, we don't care because everybody knows we're settling this. And so it's conceivable. 2, if you did get disqualified information, first, if you said, "Wait a second, I'm not going to represent you, so don't tell me anything else. Hold on," or "Let's just talk about the general type of case it is and who the parties are, and then I'll decide if I'm still interested." And and then you can tell me more, and then you say I'm not interested. So if you did something to try to like limit how many of the gory details they told you, then we actually could screen you, and another lawyer from your firm could take the case. And that's the point of D. A consultation, by the way, so I want to make something clear. So let's say somebody writes to you through your firm's website. If it's an unsolicited come on, where somebody just saw an ad for you as like hire the great lawyer or something like that, and they and the ad merely said like that you went to XYZ law school and you have all these years of experience and a great win rate and so forth, and and that you love representing clients, and then they send you one of these like 10,000 word emails explaining their whole life story. Well, that was kind of unsolicited. On the other hand, if they go to your website and fill out a form, and your inquiry form prompts them to disclose stuff like please upload your most recent tax returns here, or what is your social security number, or please describe in detail the incident that happened. So anything where you are actually asking people to tell you the information, that was our last slide, then that is going to count as a consultation even if you never met them. On the other hand, if it's an unsolicited come on and they tell you this information, 1.18 does not apply. You can condition, this is comment 5, a consultation with a prospective client on the person's informed consent that no information disclosed during the consultation will prohibit the lawyer from representing a different client in the matter. So you can go ahead and tell people, if you want, you can tell people, before you start telling me anything, you have to agree that if I don't represent you, I'm not barred from representing other people, and I can use whatever you're about to tell me. Why? Because then you've put the person on notice that they should be careful about what they say. If the agreement expressly so provides, a prospective client may also consent to the lawyer's subsequent use of the information received from the prospective client. In the absence of an agreement, the lawyer is not prohibited from representing a client with interests adverse to those of the prospective client in the same or substantially related matter, unless the lawyer has received from the prospective client information that could be significantly harmful if used. So this is an important caveat to 1.18. Again, watch out for this. This is comment 6. So a person comes in for a consultation, and they beat around the bush. You kind of know what the matter is about, but they don't, you say, so who's the opposing party? I don't want to get into that yet. And so exactly what happened, I don't want to get into it. And then they're like, I just want to talk about the money, or they want to talk about how unfair life is or something like that. And eventually you send them away and say, I'm not representing you. Well, you didn't actually get any information that could be used against them when they talk to you. And so that does happen. People go in, and this is going to happen to you as a lawyer. You have a consultation, and it drives you if you're an impatient person like me, it can drive you crazy, because it's like pulling teeth to get any of the information you actually need out of them when you're talking to them. They just waste a lot of your time. And there's people like that who are just deflect and are indirect and beat around the bush even when they're trying to communicate. Okay, comment 7. Under paragraph C, the prohibition to this rule is imputed to other lawyers as provided in Rule 1.10, but under D1, imputation can be avoided. In other words, if one lawyer in your firm does a consultation and gets disqualifying prejudicial information or confidential information from somebody during a consultation, the whole firm will be presumably disqualified from representing the opposing party unless that lawyer didn't get any more information than necessary, limited it, and hasn't shared it with anyone, and we can still screen that lawyer. There's an old ABA opinion that I just want to mention really quickly from 1990, 358, that gives a hypothetical that really lends itself to test questions. So I'm going to mention it here. An attorney undertook the representation of a client in a breach of contract claim and began working on a matter. A few weeks later, the opposing party in the litigation consulted with another lawyer in that attorney's firm about the same matter. But during the consultation, disclose no confidential information except the identity of the other party and the nature of the claim. So far, so good. So they came in and they said, I want to sue Greenacre, and you're already representing Greenacre, right? And so they don't really say much else except I want to sue Greenacre in this breach of contract claim, and it's another lawyer. So the other lawyer does a routine conflict check, quickly discovers a conflict with this new potential client, immediately declines to represent Redacre, who came in wanting is the opposing party from Greenacre, whom you already represent. So the lawyer and the attorney already representing the client, first client, discuss the situation. And so the question is it proper for the attorney to disclose, let's say you're already representing the opposing party, Greenacre, to the client that the opposing party had come in for a consultation with another lawyer in the firm? And the answer is no, no. So you've been representing Greenacre in a conflict, breach of contract claim against Redacre. Redacre actually doesn't have a lawyer yet, and 2 weeks into the representation, Redacre comes in and talks to another lawyer in your firm who didn't realize until they came in that they were wanting to sue Greenacre. And as soon as they start talking to the other lawyers in the firm, somebody says, I'm already representing Greenacre, the opposing party, in that matter. You can't then say, hey, Greenacre, you're not going to believe who came in today. It was Redacre wanting us to represent them. You can't do that unless, of course, Redacre says you can. Nor can you tell Redacre, by the way, that the reason you can't represent them is because you're already representing Greenacre, although trust me, they're going to find out soon enough if you are opposing counsel in the matter. And you're not allowed to use any information that you got from that conversation. Okay, so that's enough for 1.18 for you to get the idea. And I think that you can read through the rest of the comments on your own.